A young person there.
Mr. Ramaswamy, I'm a junior at the Phillips Exeter Academy nearby. We recently just saw Judge Dougherty agree with the attorney generals of Missouri and Louisiana that the Biden administration colluded with Twitter and other big tech to silence reports of Hunter's laptop like the New York Post, and continued throughout his administration to silence conservatives on social media. How, as president, would you confront big tech and ensure that the First Amendment is protected on all platforms?
First of all, I want to say I'm proud of a 16-year-old. How old are you, 16? 17? Really in the weeds here. And then that one hits close to home for me because that particular case and the ruling was argued in part drawing on a legal theory that this is just a coincidence. I happen to have played a small role in authoring 3 years ago on the pages of the Wall Street Journal with a former law professor of mine. And we made an argument at the time that was dismissed widely. People laughed at it as a conspiracy theory. Now it's in the mainstream of our appellate court system, which I'm proud of, which said this, right? The traditional wisdom is that the First Amendment, you all know the First Amendment, enshrines freedom of religion, free expression, that's freedom of speech and otherwise, freedom of assembly and so on. That the First Amendment only applies to the government, but that companies are free to silence speech as they see fit. Well, hold on there a second. That's true if the companies are actually behaving as companies. But it turns out, and this was evident in January of 2021 when I co-wrote that piece that these cases are now drawing on, turns out if the government is threatening companies to do something through the back door that the government couldn't do through the front door, then the Supreme Court has long held that those companies are still bound by the First Amendment. There's a case, actually, the Bantam Books case. It dates about 40, 50 years ago. There's a bookstore owner who wanted to sell a book. The prosecutor and the local government didn't like the book. They said, take it down. He refused to. They then threatened him and said, we're going to bring some case against you on an unrelated matter. Well, then the bookstore owner, I don't want to deal with that. He takes the book down. A customer wants to buy the book. He sues. They said, oh, it's just a private company. The Supreme Court said, not so fast. That was the government threatening the private company, in that case, the bookstore owner. Today, it's Facebook or Google, to do something through the back door the government couldn't do directly. Because this is New Hampshire, I'm going into a layer of depth I wouldn't usually go into here. Same thing with incentives. If the government gives you a carrot to do something the government couldn't do directly, that's state action in disguise. So there's a case involving the railroads. During the war on drugs, the government wanted to fight drugs, and they said, we want to search and seize drugs on passengers. Well, the government can't do that directly because we have this pesky little thing in the United States called the Fourth Amendment. I think it's a good thing. What the government did is they passed a law that said that the railroad employees or operators would not be liable for being sued by passengers or by employees if the railroad chose to search them. It's not the government doing it, it's just a private company doing it. The Supreme Court said not so fast. If it's state action in disguise, that you gave those companies an incentive purposely to do something the government couldn't do, the Constitution still applies. Well, what do we have now? Section 230, which tells tech companies, it's a special law that gives tech companies special liability immunity from being sued for taking down constitutionally protected content. So one of the things I've learned in my short time in this political world is sometimes you got to make things a rhyme to make them stick. So what we say is, if it is state action in disguise, then the Constitution still applies. If the government is threatening these companies and giving them carrots and sticks to do its dirty work through the back door, then these companies are and ought to be bound by the First Amendment to the U.S. Constitution. And this is, I think, if we're closing on this question, maybe I'll wrap it this way, which is to say that we live in a complicated time. The threats to liberty aren't what they were back in 1980. I believe the building we're in, I was told before I walked in here, was one where Abraham Lincoln famously spoke about 160 years ago. Lincoln said it at the height of the Civil War, the dogmas of a quiet past are inadequate to the stormy present. I say the dogmas of 1980, even in our conservative movement, are inadequate to address the unique challenges that we face in the year 2023.